very long documents, a couple of excerpts. The 7th Environment Action Program, which after all for us, environmental law practitioners, is our kind of a Bible today. Two of the priority objectives of the 7th Environment Program deal with climate change. Priority objective number 2, turn the Union into a resource efficient, etc., competitive, low carbon economy. Priority objective 9, increase the effectiveness in addressing climate-related challenges. In the field of the energy policy, obviously, we have the same type of concerns, but from an energy point of view. I would refer on the framework strategy for a resilient energy union with a forward-looking climate change policy, which is a 2015 communication from the Commission, and which I take sets the scene pretty well. We've already heard the steps taken in that direction, but we understand that the energy policy is going to focus on the consumer. It's going to favor the consumer, but also instrumentalize the consumer a little bit in the polluter pays or user pays principle line of thinking. On the one hand, the consumer will have secure, sustainable, competitive, affordable energy, wonderful. But to do that, the consumer will have to act on the market in a rational way by knowing how much he or she consumes of energy and its implications. So you instrumentalize as much as you favor the consumer. And second major concern that I have taken from that important policy document, the Commission suggests that one should move away from an economy driven by fossil fuels and a fragmented system with uncoordinated policies, market barriers, and energy isolated areas. You'll see how all that falls on the way. Quick reminder about chronology. We currently live under the, until 2020, we live under the old 2007 decisions taken at the Council level in preparation of the Copenhagen UNFCCC conference, which was supposed to adopt a post-2020, post-2012 solution after the expiry of the targets that had been set by the Kyoto Protocol. And in 2007, the Council decided that we should move towards 20% less greenhouse gas emissions, 20% renewables, at least in our energy mix, and a 20% increase in energy efficiency. That was declined for us lawyers in the 5 directives, 1 decision and 1 regulation of the Climate Action and Renewable Energy Legislative Package of 23 April 2009, one of which is the Renewable Energy Directive of 23 April 2009, which of course was at the time adopted on the basis of Article 192 within the framework of the environmental policy. Then, in 2009 came the Lisbon Treaty. 2009, it came into force on the 1st of December of 2009. And the Lisbon Treaty instituted 2 new legal competencies for the European Union. One on trans-European networks, that's Article 172, which is going to be marginal to my speech, but might have some impact on the following one. And one which is the legal basis for the energy policy, Article 194. Immediately, the legislature used Article 194 and transferred certain competencies from the environmental policy into the energy policy by switching the legal basis of the former Energy Performance of Buildings Directive from Article 192 to Article 194, and the Energy Efficiency Directive, formerly based on the environmental competency, into the energy competency, Article 194. Then came the next question, which was, what do we do after 2020? And that's what the Commission called, in a very illustrative way, the road to Paris. What are we going to do in Paris? And the Council accepted most of the proposals made by the Commission in 2014. We ought to target a 40% reduction of greenhouse gas emissions in 2030 as compared to 1990. This should be a little bit more of an effort for the ETS sectors than for the non-ETS sectors, and that's the articulation between the ETS directive that we just discussed and the effort sharing decision sectors. There should be a market stability reserve for the ETS. We just heard about that. And then, and I'm coming closer from my own topic, in order to reach that 40% reduction in greenhouse gas emissions by 2030, the Commission said, we will have to have at least a 25% improvement in energy savings in non-ETS sectors. Buildings, 40% of all energy consumed is consumed by buildings. This, therefore, improve district and heating cooling, and the other big winner, transport, of course, which is the other major source of greenhouse gas emissions. And the Commission kept saying this in itself, in order to reach a 40% reduction of greenhouse gas emissions by 2030, this in itself should encourage having a mixed energetic that would contain at least 27% of renewable energies. And at the time, the Council said, yes, but we don't want member states' objectives anymore. The member states do not want to be constrained by EU law so much anymore. You hear Poland, the UK, that's everything that we hear on TV every day. You know? Get us rid of Luxembourg and Brussels and all that. That's underlying here in the renewable energies. The Commission said as early as 2014, we have only one solution then. How can we deliver a EU level target, 40%, if we cannot look at the member states and tell them, you ought to do better? And since we will not have binding targets on the member states, we have to have a governance process. That's when the word arose for the first time. That allows us to redirect, to correct member states if they do not allow us to deliver the EU level commitment. I like this slide, which, courtesy of the Commission, I stole from somebody else's presentation a prior year, because it shows you very well that we ought to go from 20% to 40% greenhouse gas emission reductions. And the other targets, I don't comment it anymore. You've heard about this all the time, and especially this morning. One word about how that resounds at the international level. The famous or infamous Paris Agreement. It's not binding, it's nothing, it's no good, it's not going to achieve anything. What have we not heard about it? Okay, first of all, look at the preamble. The international community, 195 countries, recognize the need for action. I know some little local judges in the Netherlands or elsewhere. We are willing to act on such recognitions by the states that they ought to act. There's already a case law building in national courts. Number two, there are commitments from an international law point of view, even though the overall target, 2 degrees maximum increase of temperature, may be expressed in kind of soft law terms. What you have to look at, and that's very important for the comprehension of the current EU project, the underlying mechanics is based on nationally determined contributions that are filed by countries, as far as we're concerned, with the EU as a whole, every 5 years, and every 5 years the national contribution has to be more ambitious than the preceding one. So that in itself is a legal commitment taken at the international level for whatever is worse. But it is there. In international law, it is there. What do you have as a procedural remedy, legal governance system here? You have an enhanced transparency framework which looks like nothing. It's not peer review, it's experts review. Experts review, and with this awful thing, a facilitative, non-intrusive, non-punitive manner. You really think you're hearing a French environmental law minister speak now. Non-punitive, facilitative, non-intrusive, respectful of national sovereignty, don't place any burden of... Yeah, okay, but it's there. You know what it's called? It's called name and shame. You make commitments, every commitment has to be better than the preceding ones every 5 years, and if you don't achieve them, we'll name you and we'll put you on the wall of shame. That's the best that 195 countries can agree upon. Okay, now keep this in mind, because that's what you're going to find in the remainder of my presentation at the EU level. I'm not going to spend more time on this. We had 3 steps in the post-Paris Agreement process, at least. I mean, actually, one was taken before. That was the revision of the ETS directive proposal, because it was a few months before. Then we had 2 separate packages, one from the DG Environment, and that's the one on the effort sharing directive, and the land use change and forestry approach, which we have not put at the program today because it's not yet mature enough. And the other one from the Energy Directorate General, a second legislative package on a clean energy for all Europeans, which has already been presented to you. And that includes, as main topics of my interest, the Renewable Energy Directive and the 2 energy efficiency directives, plus the famous governance. A quick look at those. Current law is, in terms of renewables, the 2009 directive that sets a 20% reduction target by 2020 with member states' targets, binding targets, mandatory targets, and as Ludwig Kremer said, member states ought to be able to be sued in the Court of Justice if they do not deliver their targets. This is a directive on the promotion of the use of energy from renewable. That means that there's only that target that's mandatory for the member states. All the rest is optional. You may use more flexibility, more cooperation, more facilitation. I'm not going to have time to go into details of the Renewable Energy Directive, but that's the general idea. And support schemes. Support schemes, to me, is called state aids. It's how much the state is going to pay in order to fill the gap between the cost of producing nuclear energy, for example, and solar energy or wind power energy. And here we had, of course, this very crucial phase in 2014 when the Court of Justice had to decide whether, in the Ålands Vindkraft matter, whether Sweden could refuse state aids to wind electricity, wind-produced electricity from the Ålands Islands, which are very close from the Swedish coast, but in Finland. And Advocate General Bott said the directive is unlawful, because the directive allows this expressly in Article 3, paragraph 3. It says that the member states may refuse their financial support to renewable energy produced elsewhere within the EU or out of the EU. The court did not follow the Advocate General and said, well, but yeah, but it's provided for in the directive. And you know, we can't possibly, conceivably, in the current political framework, we cannot force a member state to extend state aids to non-national production. That just would not stand from a political point of view. People are not ready to pay taxes to support other member states' economies. That's not going to work. And so the court did not follow the Advocate General. I'm not going to spend time on the biofuels situation because that's very complex. What do we have today? We have two major changes in the proposed directive. And to differentiate my speech from the one that was presented to you before and which was more policy-oriented, I'm just giving you the accurate, the exact text, excerpts of the exact text of the proposal. Article 3 recognizes that the only binding target will now be that of the Union to deliver at least 27% of renewable energies by 2030. Paragraph 2, the member states' respective contributions to this overall 2030 target shall be set and notified to the Commission as part of their integrated national energy and climate plans. This is the legal beast that we're going to find as transversally as a constant legal instrument throughout the system. The second major, and so I will come back to those plans later. The second major change in the directive is that the directive is much more prescriptive, normative in the field of the financial support extended by the member states to producers of energy and especially electricity from renewable sources. And there we get the idea, which comes up in Article 4 and then really expresses itself in the new Article 5, which is that support schemes for renewable energy must be opened to generators located in other member states. This is a departure from Article 3, paragraph 3 of the current directive as confirmed by the Court of Justice in the Ålands-Vindkraft case. And as you were told earlier this morning, the Commission is not going to impose that other member states' producers be able to compete for 100% of any member state's state aids, but let's start with 10% and then 15%. You open the door, and that's the principle. And you will have there too, I guess, a basis for interconnection facilitating, because the energy concern of relying upon interconnection between national grids so that in cases of peaks of demand, you can rely on electricity imported from a neighboring member state is going to be facilitated also by the opening, of course, of the support schemes to neighboring states' financing. Another slight but very important new provision in the new directive is Article 6, which requires the states to ensure stability of financial support. You may know about the Spanish, the 39 investment treaty. Spanish case is currently pending because Spain suddenly changed its photovoltaic support scheme. That's just not possible. Energy requires decades of investment, decades of planning. You have to have a stable legal environment. And this cannot be changed every other year because environment protection requires all of a sudden that you change this or that. You are not going to achieve anything if you do not provide some stability. I thought I would give you an idea of the difficulty of getting all this together. I see my time elapsing. This is just visual. To give you an idea of the importance of this support to renewable energies in the EU, you see that in the left picture, you see that environment protection, including for 80% or 90% energy saving and renewable energy, is one of the three and by far the most significant field of state aids in the European Union. You also see on the right-hand chart, that this is extremely diverse because what you see here is the types of policies in the various member states. The member states have very heterodox behaviors in that field, and that, of course, raises a number of questions. It has already been mentioned that there are a few other novelties in the proposed new directive. Entitled people who have a solar panel on their house to use themselves the power that they produce and not be forced to sell it on the grid. Facilitate their lives if they do want to sell it on the grid and if they do want to use it for themselves. A very German thing, which is renewable energy communities. We don't even know what that is in France, but it is to recognize that people may get together to favor production of renewable energies. Mainstreaming renewables in heating and cooling, and favoring a market behavior in the district heating and cooling, making sure that a community, a building, or a consumer may leave its utility if that is not the most efficient one in the area. I spent a lot of time on renewables, but this is the, if I show you the paper, the document itself, it is by far the most complex change as per current law. The two energy efficiency directives, I will deal with them together. I call them the twin energy efficiency directives because they're very interlinked. The first one is on the performance of buildings, the second one is on energy efficiency. The 2010 energy performance of buildings sets forth requirements in terms of building performance, isolation, heating and cooling performance for new buildings, obviously. But what do you do about old buildings? That's where the waste is. It's in old buildings. And that's a major problem. So the standard set by the directive for new buildings also applies to major renovation projects, i.e. more than 25% of the building is being changed. And to do that, to achieve that, the member states are required to take a number of steps. The Energy Efficiency Directive of 2012 sets targets for the member states to improve their energy efficiency, including mainly by providing for a long-term building renovation strategy. You see, I just highlighted in red right now those two important concepts. The Energy Performance of Buildings Directive deals with new buildings and major renovations. The Energy Efficiency Directive requires the member states to have strategies to entice building renovation. And that makes a lot of difference because, of course, this is where there's a lot of advantage to be gained in terms of climate change combating. What the Commission now proposes is to switch Article 4 of the Energy Efficiency Directive from that directive into the Energy Performance Directive. You would take the member states' duty to develop long-term renovation strategies from the Energy Efficiency Directive and paste it as is in the Performance of Buildings Directive so that you would have a coherent instrument. In addition to that, the proposal would require the member states to set clear milestones and measures to be delivered, you know, something that the Commission could monitor. You would have to have a clear plan and mechanisms in order to facilitate renovation. What do you have to do to facilitate renovation? You have to put together state aid plans so that there'll be actors on the market to finance the temporal gap. I don't own my apartment, I rent it. I have no interest in investing in its renovation because I'm not going to stay 30 years and recoup my investment. The owner of the apartment is not interested in investing because he's not paying my gas and electricity bills. So nobody is interested. If you resolve, that's an economic thing, if you resolve the intertemporal gap, then you might have investment decisions. That's pretty much the underlying concept in the Energy Efficiency Directive. You will find very interesting things in terms of having recharging point for electric powered vehicles in new buildings and renovated buildings, whether residential or not. There's no point in buying an electric car if you do not own a parking space with a plug where you can recharge it. That kind of things will be improved in the new Energy Performance of Buildings Directive. In the Energy Efficiency Directive, there's no major changes except that one removes Article 4 from it to put it in the Energy Performance of Buildings change. I want still to note that basically what the proposal does is extend the trends that had been set forth by the 2012 directive for up to 2020 at the time. The proposal would extend those to 2030, pretty much on the same trend. The member states will have to set indicative national energy efficiency contributions. How strange, again, national contributions. And they will have to have at least minimal contributions of 1.5% reduction of energy consumption per year. But if you compute that, I did it last night, you come up to 23 or 25%. So it is not, it looks like nothing, 1.5% per year. But if you run it until 2030, you have a very significant improvement. And that is a legal requirement. Let me not spend more time on the rest because my time is elapsing. Again, there are important improvements, but which are more technical in the way to inform consumers of their consumption, empower them to make their choices, metering, billing, consumption information. Your invoice is much be clear. You must have access to independent individual meters to see how much you consume at what time and adapt your behavior depending on how it costs, what it costs, and how it works. But I have no time to get in. A word of conclusion, because my time is over, and then it is about implementation and delivery of contribution. I just want to show you, because it's been explained to you with pictures. Now I want to show lawyers what lawyers live with, which is legal provisions. So I just, again, cut and paste from the directive a few words which I find to be of interest. The very most important thing in the proposed governance regulation is that member states are going to have to adopt integrated national energy and climate plans. We're going to have to live with those for a long time. Those will have to cover the ETS, the allowances for the main emitters, the effort sharing decisions, so-called non-ETS sectors, the renewables targets and achievements, the energy performance of buildings target and achievements, and the energy efficiency at large target. This is going to be a catch-all kind of a document that the member states are going to have to prepare for a 10-year duration. This is no small story. It is a big thing to do. And obviously the question of public participation in here, I interject in the earlier debate, is of utmost importance. Because the Aarhus Convention follow-up committee, I don't remember its name in English right now, the Compliance Committee, thank you, has made it very clear that the provisions of the Renewable Energy Directive, as far as public participation is concerned, are not in compliance with the Aarhus Convention, and has found the EU to be in breach with respect to its obligations to allow the public to participate in the adoption of the energy, of the renewable energy action plans. It's going to be exactly the same, in my opinion, mutatis mutandis, for these transversal, catch-all plans. Okay. The member states will have to submit drafts of those plans to the Commission. The Commission may make recommendations, and look at the bottom of the page. Member states shall take the utmost account of any recommendations from the Commission. Is there going to be a remedy, sanctions, if they do not take account of the Commission? This is obviously open to litigation in the Court of Justice, but do we not all have a duty to cooperate in good faith under Article 5 of the treaty, la coopération loyale, loyal cooperation, and could a member state not be found to be in breach of its obligations? And this is going to be the last idea. The Commission is then going to receive reports from the member states on the status of the implementation. The Commission will check the progress made at the Union level towards meeting the objectives that are the EU's commitments to the Paris Agreement in international law, and the Commission will check the achievement of the member states toward their own contributions. If they don't, the Commission can propose measures at the EU level, new directives, new regulations. It will have to do that. It can issue recommendations to member states, and in the area of renewable energies, it can have the member state pay. Oh, it's not a fine, it's not a sanction, it's a contribution to a financing platform. That's the same thing. There will be financial sanctions. All right, this is the entire thing. What's going on here? What's going on here is that the energy policy has no power at all in terms of energy mix, and therefore of delivering climate change targets. Because, as we all know, Article 194, paragraph 2, does not allow the energy policy to impact on the member states' energy mix. And the environmental policy at Article 192, paragraph 2, can do it only with the unanimity of the agreement of all of the member states. And therefore, there's no way that the EU can comply with its international commitment other than by entering into this iterative process and monitoring process, which very much looks like the one set at the international level in the Paris Agreement. I'm sorry, Mr. President, for having been so long.